All right, so hello everyone. This is the rights of recipients of mental health services who are children in need of service. My name is Anna Schmidt. I'm a children's advocate with Disability Rights Maine, and I will let Amanda introduce herself as well.
Hi, I'm Amanda Hodgkins. I am one of two residential specialists that works for the state of Maine.
Awesome. And we will provide all of these links and things at the end of the training, as well as our contact information. All right, so moving on to the next slide. So this is for educational purposes only. I am not an attorney. Amanda is not an attorney, so there is no client-attorney privilege created through this presentation, and it really is for educational purposes only. So we will provide information of how to find updated information at the end of this presentation, but it's intended to be accurate as of our recording date. So yeah, we can go to the next slide.
The goals of this training are to review the rights of recipients of mental health services who are children in need of service, to understand and protect children's rights when providing residential and inpatient services, to understand grievances and complaints, and to understand reportable events. And we hope that you leave here today with a better understanding about these topics and the knowledge of whom to contact with further questions or concerns.
Great. So talking a little bit about our scope today. So we're specifically talking about the rights of recipients who are children while they're receiving behavioral health treatment. The legal basis that we have for this is this 34B. And these rules apply to any facility, program, anything like that, agency that is funded, licensed, or contracted by the Department of Health and Human Services. I also want to note that under the sort of label of children, we also include children with intellectual disabilities and children with autism.
So the Office of Children and Family Services utilizes an electronic system called EIS, which stands for Enterprise Information System, to collect reportable events from children's providers. And that includes community providers and children's residential care facilities, and ODS reports for those youth that are in children's programming, but eligible for ODS. So reportable events encompass various categories to include medication errors, dangerous situations, restraints, isolation and seclusion, rights limitations and restrictions, serious injuries, abuse and neglect, suicide, and unfortunately at times death. Reportable events are emailed to screeners, myself and Lana, each day. If all the elements of the reports are clear, then the report can be closed out. If questions remain, or if the content of the report raises concerns, we may follow up with specific providers. We may contact the data enterer, the clinical supervisor, or the program manager to clarify aspects of the report. One common reason that results in the need to reach out is a missing category, to include things like missing data, guardian notifications, debriefing narratives that are left blank. Another example would be if a restraint included a rights issue. For example, we would reach out and ask that the rights limitation restriction category be added to the report. Some entries rise to the level of needing to be reported by the provider to Children's Protective Services directly, as obligated under the Maine's mandated reporter statutes. Child's Protective will sometimes send reports onto licensing for continued follow-up as needed. Lana and I check to see that these reports are sent to the appropriate level of supervision.
So going on to the basic rights that children have while they are in treatment. So children in treatment have the same human, civil, and legal rights as all other minor citizens. So this can include things like if they're 18, they're eligible to vote, they have a right to free speech, right to assembly and press, and all of those other ones that are guaranteed. Limiting a child's religious belief is prohibited. as well as discriminating against them based on a protected class. So whether that is religion, race, gender, sexual orientation, or disability, or any of the other ones, that is also prohibited. And I think the most important sort of key point in this slide is that rights are not privileges. That means that in a situation, they cannot be removed as punishment, or they cannot be granted as reward. They just exist regardless of the situation. All right, Amanda, this is yours, right?
Yeah. Least restrictive appropriate treatment. So youth have the right to be treated to the least restrictive available setting and to not be held in treatment against their will except by the order of the court, emergency hospitalization procedure, or consent of the legally responsible parent or guardian. Least restrictive settings always need to be considered first. Emergency hospitalizations are not utilized as a means to an end. For example, to get youth admitted to a hospital, or as a way to get youth into residential treatment, or to secure placement for the youth.
All right. So youth and their legally responsible guardian must be notified of their rights by their treatment provider. And I think the key part of this is it has to be in language that is understandable. So, someone shouldn't have to be an attorney in order to understand their rights in treatment. It should be provided in a way that any average person can understand. Also thinking about accessibility factors. So, does there need to be an interpreter present? If they are not English speakers, would a follow-up in writing be helpful? Thinking about those factors to make sure that this information is provided in a clear and accurate way that is understandable for the youth and for their parent. Youth and their parents also have an entitlement to get help in protecting their rights. So that can include naming a representative like an attorney or an advocate. And that help can include things like participating in team meetings or assisting in the grievance process, which we will get into in just a second. So going back to due process and grievances, I want to define what due process is. It's essentially the rule that in a legal case, things have to be done a certain way that protects the rights of all the parties involved. So youth have a right to that regarding their grievance. And every provider is required to have an internal grievance process, which I believe should be outlined in the handbook. You probably have access to that within the handbook. And grievances can include, but are not limited to, violation of rights, the inappropriate or disagreement about treatment or the method of treatment, policies, procedures, actions, or lack thereof by the agency or the facility. Okay. So continuing with the grievance process, so the Rights of Recipients offers a forum for resolution of grievances during the course of seeking or receiving treatment. And so the grievant or the person filing the grievance has two options in order to be heard. So the first is an informal mediation. So in mediation, a meeting is held with both parties. So whether it's the grievant in the facility or the grievance legal guardian, a meeting is held for them to go over concerns. And it's usually held at a time and a place that's convenient for the person filing the grievance. An impartial party is generally the one that helps facilitate this meeting and reach a solution. And attorneys can be present, but they are not mandatory for this resolution method. And an agreement is only reached with the full involvement and approval of the parties in the dispute. And then the other option is an administrative hearing, which tends to be a bit more formal, a bit more official. So it's generally conducted, or I guess it's always conducted, by an impartial hearing officer from the Office of Administrative Hearings, and that's through the state of Maine. and it is conducted with state law and will be electronically recorded. And again, it should be at a time and a place that is convenient for the grievant, as well as when a hearing officer is available. Those sort of links and forms can be found at this link that I have in the PowerPoint. And I know we have a bullet on stay put. We'll get into that in the next slide. But a filing of a grievance stays or pauses any action to reduce, terminate, or suspend any service. So stay put, we just talked about this. So it's the filing of a grievance that stays any action or reduces, terminates, or suspends any service. So what that means is if a grievance is filed, specifically around discharge or things like that, changes in a treatment plan, that cannot continue unless the grievance is resolved. So an example of this would be a residential provider brings a child to an emergency department during an acute crisis, and at the same time issues a discharge notice that they have to leave the program. Generally, this discharge plan wouldn't have had any sort of pre-thought to it. It doesn't consider what needs to be put in place in order for the child to be safely discharged. And that child's guardian files a grievance, and that pauses the discharge, allowing there to be time for there to be a safe discharge plan put in place.
Confidentiality and access to records. I hope I didn't cut you off, Anna.
No, not at all.
Okay. Youth and families have the right to access their records. Records shall be made available within 3 working days. All information regarding mental health care and treatment is confidential. If there's a clear and substantial reason to believe there is an imminent danger of serious physical harm to the child or another, confidentiality may be waived. Such requests for records will be made available within 3 working days. Review of the record would be under the supervision of a designee of the facility or program. In cases in which a recipient is unable to review the record at the program site, a certified copy of the record shall be forwarded to a professional designated by the recipient in the recipient's area, who shall supervise review of the record. A recipient may also add any material to his or her record. For example, if there seems to be some information that's inaccurate or incomplete, they can submit to correct that.
Great. So fair compensation for work. So youth have the right to be paid a fair wage for work, regardless of whether or not that work is considered therapeutic. And they must be paid at least minimum wage or higher. We haven't included a specific dollar amount just because that changes, but you can find more information on that at this link. I also think it's important to note that this doesn't necessarily cover things like chores within a residential home. So things like asking a child to clean up after dinner would just sort of be part of living life at a residential facility and wouldn't be considered work. Work is generally considered as something that creates economic benefit for the agency. And at that point, a child would have to be compensated.
Right to humane treatment. Youth have the right to be free from abuse, exploitation, or neglect, to not be subjected to humiliation or verbal abuse, to not be subjected to physical abuse and corporal punishment, to be treated with courtesy, respect, and individuality and dignity, and to recognize that their personality, needs, and aspirations are not determinable on the basis of a psychiatric label. So individualized treatment respects the individuality of the youth, and the comprehensive assessment and the treatment plan should reflect that. Some examples of things that have been reported through reportable events under this category are inhumane treatment, such as denying food due to behavior, degrading a client, such as laughing at a client who's upset and crying, and the use of physical intervention when safety isn't at risk, or using an intervention that's not approved. So each facility should provide nutritious food in adequate quantities, access to provision of adequate professional medical care, a level of sanitation, ventilation, and light, which meets health standards, a reasonable amount of space per person in sleeping areas, a reasonable opportunity for physical exercise and recreation, including access to outdoor activities, individualized treatment and discharge planning, an area for private conversation with other recipients and family, and an area for private phone calls. Youth must also have access to areas which assure privacy for personal hygiene, counseling, physical examination, secure and accessible storage area to accommodate their belongings, opportunities for appropriate involvement in community activities, and common areas and space that are sufficient to permit recipients to comfortably socialize, relax, or engage in leisure activities. Recipients, again, have the right to be free from abuse, exploitation, or neglect. They should not be subjected to humiliation or verbal abuse, or physical abuse, corporal punishment. And recipients shall not be subjected to exploitation or neglect. Any allegation of abuse, exploitation, or neglect shall be immediately reported to the following: the chief administrator of the facility or agency, to the Office of Advocacy, and to DHHS.
So this is probably just reiterating everything that Amanda just went through, but thinking about what you need as an individual in order to live a happy and healthy life. And I'm sure that's sort of reflected in this slide. So again, access to nutritious food, access to medical care, whether it's preventative or in an acute way if you're injured or sick, being able to physically exercise and go outside, have phone conversations, and just time to relax and socialize and not necessarily have structured time.
Personal property. Youth have the right to keep and use their personal property, except when that infringes on the rights of others or if the property poses a safety risk. Removal of children's property must be documented and include a plan to return their property when appropriate. It's not permitted to take a client's property without due cause. So when we do reportable events, we look for safety reasons and a clear plan as to when that property will be returned. An example would be a client walks in to find staff searching his room, and another would be a client's craft supplies are removed and held for several days without clinical justification and without a plan for return. Searches. Every child has the right to be free from unnecessary searches of their person, personal space, or common area. Searches may only be conducted when staff have a reasonable belief that stolen items are present or the property would endanger the health or safety of a child or others. Every search and reasons therefore shall be documented. Again, for reportable events, we look for information that supports that a search was in order. If it's clear that a search was conducted due to safety concerns, we're not likely to reach out for more information. For example, if the report notes a client was expressing suicidal ideation and self-harming earlier in the day, we're not likely to follow up since it's clear that safety was a concern.
So let's talk a little bit about individualized treatment. So youth have the right to treatment according to a written and individualized treatment, service, and discharge plan. And every youth ages 14 and over has the right to be actively and fully involved in the development and revision of their plan. And I know that it says involvement of younger recipients is on a case-by-case basis. I highly encourage involving younger kids if it's clinically appropriate. I think that this really promotes autonomy and agency in their treatment. and bodes for a better outcome. And children and their parents and guardians should clearly know what is in that discharge plan or in their treatment plan, and they should be able to receive a copy upon request. And again, I think this goes back to making sure that this is understandable. So is this written in language and communicated in language that is understandable to that family? Okay. So this sort of relates to the last slide. So informed consent has to be provided. So treatment may be provided to a youth only when there has been informed consent obtained for that specific treatment. So whether or not that has been obtained from their legal guardian, or if they are 14 years or older, they have to provide their own informed consent, and that covers medication as well. And again, I think it's important to be having those conversations with youth who are under the age of 14. Even if they can't legally provide their own consent, it's still important to have that autonomy and agency restored as much as possible. All right, so visitation. So children have a right to regular, liberal, and daily visitation in areas that are provided by the facility or by the agency. And there is unrestricted visitation provided to a child's attorney, clergy member, professional service provider, advocate from the Protection and Advocacy Agency, which in the state of Maine is Disability Rights Maine, and an educational surrogate for parents at any reasonable time.
Family visits, as an example, should not be lost as a consequence to behavior. Certainly, if going home is a safety concern, that's one issue, but visits shouldn't be removed due to behavior. If there's a safety concern that comes up, canceling a visit, Lana and I will be looking to see if the family is encouraged to come into the program to continue the visits and family connection/treatment. If visits are denied based on behavior and there's no clinical indication that the visit shouldn't happen, the rights limitation restriction category should be reported to EIS.
All right. So we get a lot of questions on this communication slide and the next slide, which is also about communication. So hopefully this clears some things up. But any incoming or outgoing mail, which includes letters and packages, cannot be censored, delayed, or restricted. Youth have a right to reasonable phone access for confidential calls, and we define a reasonable time as 7 a.m. to 10 p.m. And they must have access to contact a designated family member, clergy member, professional service provider, or a personally designated representative, as well as access to an advocate for the P&A or Protection and Advocacy Agency, or to an attorney.
Some examples of things we've seen in reportable events are a client requests to call a grandparent and is denied without reasonable justification for the denial. For example, it isn't midnight and the contact is not contraindicated. Another example would be a client's having a hard time and wants to call mom at 9:15 and was denied because he didn't want to call at 8. It's important to know in the report the rationale for why a client was denied the phone call. Was the youth being unsafe, breaking the phone, not enough staff? Are there clinical reasons that the contact should not be made at this time?
And hopefully this exception slide also answers some questions. So like Amanda was talking about, this has to be clinically determined if there is some kind of prevention to communication or limit to communication. It has to be specific and limited to a reasonable period of time, and it cannot exceed a week without reauthorization. And it's really important that it's incorporated in the treatment plan and it becomes a focus of treatment. And so an example of this would be, let's say Amanda and I were friends outside of treatment. Maybe we didn't make the best choices together. There could have been criminal activity or substance use when we were together. And so it probably makes sense for me not to have contact with Amanda while I'm in treatment, but there has to be a reason for that. So are we focusing on boundary building, or is there substance use treatment happening? and consistently reevaluating whether or not that would be a safe contact for me to have.
Freedom from unnecessary seclusion and restraint in residential. Seclusion is only permitted when facility staff is standing in or near the doorway while engaging in approved de-escalation techniques. Restraint is the immobilization of a recipient's arms, legs, or entire body by an individual, or through the use of an apparatus that is not a protective device. Restraint is only used when absolutely necessary to protect the recipient from serious physical injury to self or others, and only after less restrictive measures have been tried and shown to be ineffective. Isolation is referenced in licensing rule and is allowed. Isolation means the removing of a child from a stimulus by use of involuntary separation and restricted activity. Isolation includes adequate supervision in an unlocked room where exit from the room is allowed. Locked seclusion means the solitary involuntary confinement for any amount of time of a resident in a room with a door that is locked, barred, or held shut by staff. Locked seclusion is prohibited in children's residential care facility, except for level 2 facilities. Level 2 are considered inpatient settings. Restraint may be utilized by the facility in a dangerous situation where safety is at risk and must be done in accordance with the most current version of main rights of recipients of mental health services who are children in need of treatment for residents under age 18 and rights of recipients of mental health services. For residents that are age 18 and older, restraint or seclusion may only be employed under the following circumstances. A, the intervention is absolutely necessary to protect the resident or others, and it is not to be used to address the comfort, convenience, or anxiety of staff, or as a form of coercion, discipline, or retaliation. B, the intervention is the least restrictive emergency safety intervention necessary to resolve the problem, and only after other methods have been proven ineffective or inappropriate. C, the intervention is performed according to the facility's behavior management policy. And D, the intervention should not result in harm or injury to the resident and must only be used to ensure the safety of the resident and others. An example from reportable events would be the staff on duty held the client's door shut in anticipation that he would escalate when he had not demonstrated behaviors that posed a risk to himself or others. Staff barring the door without engaging in de-escalation techniques. Most of the reports we receive from residential are restraint reports, including isolations. If a report clearly reflects the following, we close the report at the first reading. Number 1, antecedent or precipitating factors. Number 2, non-physical efforts and interventions used to help calm the client. Number 3, if a physical intervention is in order, a description of that intervention and how safety was at risk. 4, debriefing with the client and staff afterwards to problem solve alternate solutions in the future. If we notice a youth is restrained frequently, we may inquire about the treatment plan or crisis plan, and we may be interested in if there are any changes that are going to occur to those documents. And we also are interested in staff debriefing, which may involve talking about changes that could reduce restraints in the future. Overall, we're looking at safety and well-being trends, including increases and decreases in numbers of restraints. Every recipient placed in a restraint shall be frequently monitored and released as necessary. Documentation shall be kept every 15 minutes. If a recipient communicates via sign language, consideration will be given to restraining the recipient in a manner to permit the use of hands for communication. And the parent legal guardian should be notified of restraint, seclusion, and isolation, and should be invited to debrief if at all possible.
All right, so that is the end. Brielle, if you want to move to the next slide, actually. Okay, So these are sort of some resources that we have collected for everyone. These links should still be updated. There's one for Disability Rights Maine, for the OCFS website, the National Disability Rights Network, and we also have a Youth Rights RAC card, which we will bring with us when we do monitoring visits to different facilities. And then I believe our contact information is on the next slide. Yep. So feel free to contact Disability Rights Maine or OCFS. Amanda and Lana's numbers are down below, as well as Cassie Antonelli. And feel free to reach out at any time with any questions. We hope that this gave you a better picture of what the rights of recipients are, but please feel free to reach out with the questions. Amanda, anything else to add?
Thank you very much for participating.